I see. Good afternoon, everyone. Welcome to our webinar on privacy data protection in Canada. We're going to get started in a few minutes. I see people coming in. I'll just wait a minute or so to let people fill up the room.
Yes, you're live. Yes, you're live. No. My mother has just told me that she's taking off to Nova Scotia. She's finally been able to escape and go for her summer holiday, so she's very happy.
Okay, so we'll get started and we'll just let people come in as we get started here. So again, good afternoon, everyone, and welcome to our webinar on privacy and data protection in Canada. My name is Lucy Brunetti, and I'll be the moderator for this webinar. Before we get started, I'll just let you know that you can feel free to ask your questions throughout the webinar by typing in the Q&A box. You'll see a Q&A box at the bottom of your screen. And we will get to those, and we'll have also a small question period at the end. So now I'll introduce our speaker. Today, we're very fortunate to have with us Danielle Olofsson to guide us through this very important and interesting topic. Danielle is based here in Montreal and is responsible for BCF's compliance with existing data protection and privacy legislation. She also advises clients from a variety of industries such as pharmaceutical, medtech, financial services, and communications on a range of matters linked to privacy data protection and cloud computing. She assists with compliance, breach identification and notification, cross-border information transfers, and privacy program management. She is particularly well versed in the privacy and data protection issues relating to technologies such as artificial intelligence and blockchain. Danielle is an International Association of Privacy Professionals certified expert in Canadian and European data protection, as well as in privacy program management. So without further ado, here's Danielle Olofsson.
Thank you, Lucy. I really appreciate the introduction, and thank you to everybody here who's listening to this. Last week we did a presentation on AI and blockchain and the challenges that these technologies pose to privacy. And this week and next week, we're going to be running a series of privacy talks. Today, we're doing an overview of Canadian privacy legislation. Tomorrow, we'll talk about the healthcare system and privacy in the healthcare system. And next week, we'll talk about the European data protection legislation and the American data protection legislation. But I will get back to the topic of today. And I will skip my bio because it is... All right, so the purpose of today's lecture is to provide a brief overview of privacy and data protection in Canada. Now, please, please, please interrupt me with questions. Lucy's agreed to cut me off and read the questions so that I can answer them as I go along. I love this topic and I can go on forever, and I don't want that to be the case here. I want people to be able to come away with some knowledge and not just my rambling. So these are the topics that we're going to address. It's a pretty crowded agenda. What I want to talk about to begin with is just introduce the topic and talk about the trends in data protection. Then talk about the fair information practices. Those are super important, especially if you're interested in this topic, because no matter where you are in the world, the fair information practices will be the same. So if you understand those, you can pretty much feel your way around data protection legislation in any jurisdiction. Then I'll talk about briefly the various models for data protection legislation. And finally, we'll address Canada. The bulk, obviously, of this presentation will be on Canada. I'll talk briefly about how privacy works when we talk about criminal law, and then we'll talk about the private sector and how that works. And that really is what concerns us the most today. So to start, modern trends in privacy protection. Although the concept of privacy has always been around, and this goes way back thousands of years, we really started to talk about the notion of the right to privacy in the late 1800s. And it came about in a strange way, and that was with the advent of flash photography, and so the paparazzi. And there was a very interesting article written by a very well-known American judge, Brandeis, and he referred to privacy as the right to be left alone. This didn't catch on very well in the United States. However, the United States has been one of the first, or is one of the first, common law jurisdictions to really protect privacy and the tort of privacy. So we move along to mid-century, and we live through a horrible war. We lived through several wars, but one in which human rights became a tremendously important issue. And following the war, there was a tremendous push to say, okay, this cannot happen again. And we are going to list, or we're going to come up with a bunch of rights that we believe are extremely important and must from now on be respected. Privacy became one of those rights. And so the right to privacy was very much associated in the second phase with the right to one's physical integrity, the right to our home, and the right to our family. So you couldn't just have your home barged into by forces and you taken away. You couldn't be spied on, all of these things. So that was when the second wave of privacy came about. And then, so we move on further to the end of the 20th century, or mid to end 20th century, and we have computers. And we realize, oh my goodness, these machines can process a tremendous amount of data on anything, and notably on people. And so the right to privacy evolved in the right to control the information that concerns us. And so the privacy legislation that is still around today, even the European one, the recent legislation, is very much based on this notion of giving an individual as much control as possible over their data. And then we reach what we have now, which is big data, the Internet of Things, artificial intelligence. And here we have all of these technologies that are really throwing into question the premises upon which this third wave of data protection or privacy protection is based. And it's really throwing into question the principles that are at the very basis of our data protection law. So it's a really exciting space to be in right now, because you see how our law is really, really, really being challenged by the technology and by the way life is evolving around us. And how do we do this? How are we going to make the two work together? So that's my little introduction, and that's where we are now.
Sorry to interrupt.
Yes,
there's a small buzzing. There's a buzzing sound. Perhaps do you have a headset or?
I'm trying. I don't. Let me see. I do have a headset. Let me see if it works.
Or it's your microphone. Do you have a headset with a microphone?
Yeah, I do. Can you hear me?
Yes.
Is that any different?
Yes, it's better. Thank you.
Okay, thank you very much. So to go to the next slide, we're talking about, so I was talking about fair information practices. And these fair information practices were again developed following the Second World War. They were developed at first by many organizations, among which is the Organization for Economic Cooperation and Development, the OECD. And because we're dealing with Canadian legislation today, the Canadian Standards Association, or CSA, has very much the same standards. And I'd like to run through these because these are really, really the basis, as I was saying, of our data protection legislation. So if you understand these, you're going to understand just about anything. So we have, in Canada, we have 10 privacy or fair information practices. The first one is accountability. This is a really important one, and it's becoming increasingly important in Europe. And what this means is that if I collect data about you, I need to be very transparent about, or fully transparent, about the way I use this data. Who am I collecting? Why am I collecting it? What am I going to do with it? Who am I going to transfer this data to? Can anybody run analytics in the background on your data? How am I going to protect your data? How am I going to dispose of your data when I finished using it? All of this information must be provided at the time that your data is collected or before. So that's what it means to be accountable. If anything happens to your data, I'm responsible. It's not somebody else's fault. Even if I've contracted some of the processing out to a third party, ultimately the buck stops with me. So if something happens, I must notify you and I must face the consequences. Then we have identifying the purpose. I must, in my accountability, I have to define the purpose for which I'm collecting your information. This is an extremely important category because much of the rest of the fair information practices rest on this. Because I cannot go and collect information willy-nilly on whatever I want. I have to have a purpose for it, and I must express that purpose. And this ties into the next fair information practice, which is consent. I must have your consent, barring certain exceptions, in order to process your information. What this means is that in order for you to provide adequate consent, you must be fully informed as to what I'm going to do with your information, and therefore I have to identify the purpose clearly. Now, consent in Canada is absolutely the cornerstone of our fair information practices, but it doesn't always have to be explicit in Canada. In Europe, it does. You have to acquire explicit consent, explicit consent. But in Canada, that isn't the case. I can have situations where I can rely on implicit consent. And I can give you an example of this. There was a case where an employee, I guess he pursued a gym. It was a facility, a health facility, a gym, because the gym had disclosed to this person's employer how many times this person had visited the gym. Now, there was an agreement in place between the gym and the employer. It was one of these agreements to help encourage employees to get into shape and to encourage health. And the employee was benefiting from this plan when he was attending the fitness center. But he was unhappy at the end of the year when the employer said, okay, I want to run stats on how many of my employees have actually attended to make sure that I want to go ahead with this next year. He was unhappy that his information was transferred to his employer. He took this to court, and the court said, yeah, okay, you're right, it's personal information. You're right that your consent had not been obtained, but you know what? It's a pretty low level of personal information. First of all, the number of times you visit a gym, and second of all, your consent is pretty much implied because you're going along with this program. So you don't always have to have a black on white, I agree to the following. But if you can, it's a good idea. And in certain areas, it's much more important than others. For instance, marketing. If you are going to take somebody's information and use it for marketing purposes, while you may be able to do that, it's always good to get an explicit consent. And an individual can always withdraw their consent. So you have to be able to react to an individual's request to withdraw their consent for your processing of their information. And just as an add-on in that, if you're trying to obtain consent through an online form, for example, pre-checked boxes are a really bad idea. The courts don't like that. So you really do have to break down each activity for which you would like to have consent, and you have to let the individual check the boxes that he or she wishes to check. I think I saw a question. Lucy, do we have a question?
Yes, it's just about having a copy of the slides, but we are recording. I put this in the chat that we're recording this session, and we'll post the recorded session on our website in the next few days.
Thank you. So to go on with my fair information practices, the next practice is limiting collection. And this is why the identifying purpose is so important, because I have to limit the collection of the information to the purpose that I've identified. I cannot, even if an individual has consented, I cannot go and collect more information than is required to fulfill the purpose that I've identified. And that's a really important one. And so you have to ask yourself, is the information I'm collecting really necessary? There was a case earlier, well, 20 years ago, 15 years ago, where TJX winners got in trouble because it had a program whereby to prevent theft or to reduce theft in its shops, what it would ask for is a driver's license every time you checked out. Because what it wanted to do is when somebody brought a product back, they wanted to make sure that they could compare that person's driver's license with the initial sales receipt, so that people wouldn't just steal things from the shelves and then come back and try and redeem them for cash. So it had this practice of every time you check out, collecting a driver's license. There was an information breach. The company helped as much as it could with the investigation, so they weren't trying to obstruct justice in any way. But during the inquiry, what was discovered was the collection of the license was just too much information for the purposes. You didn't need a driver's license in order to check somebody out. So you just always have to make sure that the information is really what you need. Instances or some other examples of what I've seen is when you try to build up a client database because you want to be able to recognize certain things. So client's birthday, okay, that may be legitimate, but you don't need the name, and you don't need the name, you don't need the birth date of his wife or his children or her husband, her children. You don't need that information. That's just way above and beyond your marketing purposes. So be careful when you're constructing databases to make sure that you really are limiting your collection. And then tied into that is the limitation of use, disclosure, and retention. And what I mean by that is that my information can only be used for the purpose I've identified. If I want to use it for another purpose, I've got to go back and ask for consent, which means that I have to disclose what I'm trying to do with it, and I have to leave it up to the individual as to whether or not they want their information used for that other purpose. I cannot disclose the information for a purpose other than the one I've identified, and I cannot keep it, retention, I cannot keep it for longer than is necessary. And that's a really important one because for two reasons. You want to get rid of information that you no longer need, because if there's a data breach, you must advise people that their data has been breached. It is much easier to advise 2 years worth of clients than it is to advise 10 years worth of clients. The other reason it's really important to limit that retention is because of our next principle, which is accuracy. I have the obligation to make sure that the information that I am using is accurate. And it's a lot easier to keep more recent information up to date than it is to keep older information up to date. So there is every reason under the sun to limit retention. Accuracy is also important, especially right now when we're developing technologies, for instance, to track this pandemic that has affected all of us. There are some devices that are being used to track, but their accuracy is questionable. When you're tracking somebody because we believe that they can spread a virus if they're within 2 meters of somebody, a tracking device that is accurate within 5 meters or 10 meters is not a good tool. Decisions are being made based on the accuracy of your product. And if it's not accurate, you're opening yourself up to a lot a lot of trouble potentially later on. So you want to make sure your information is accurate. We have to put in place proper safeguards to secure information. So those are, we want to put in place technological safeguards. We also want to put in place operational safeguards and physical safeguards. Physical safeguards, I want to lock filing cabinets that contain personal information. Operational safeguards, I want to make sure that I have the proper data protection policies in place. Individual access, this is a very important one. An individual whose information is being processed must be given the right to know that their information is being processed and to have access to that information, and even to be able to rectify that information if they believe that information is inaccurate. So that's a very important practice. And finally, challenging compliance. Every individual has the right to challenge my compliance as an organization with various data protection legislation. If they don't believe that their information is being treated properly, they can challenge me. They can first take it to my organization and say, I want to talk to your person who's responsible for data protection. And if they don't like the way that that person has handled their complaint or their challenge, they have the right to take that over my head and go to the Privacy Commissioner either of Quebec or of Canada or whatever jurisdiction you're in. So those are, by and large, the fair information practices that all the legislation, regardless of whether you're in France, whether you're in Korea, whether you're in China, it's all based on these fair information practices, which is why this is such an interesting area, because we all have to sort of behave in the same way. And it also makes it very difficult for a country to say, well, you know what, I'm developing my own data protection regime. It doesn't work that way. You can't do that because we all have to trade with each other and we all have to get along, and you can't just go rogue in this area. Are there questions before I go to the next topic? Okay, well then I will go. There are, throughout the world, various models for data protection, even if we all have the same principles. Canada, for example, and the European Union have what we call a comprehensive model, which means that we have, in Canada for certain areas, in Europe generally, one law that applies to everybody across the board. And you have to abide by it regardless of what sector you're in. In the United States, which stands in stark contrast to the European Union, it's a very different approach, and we'll deal with this next week. But in the United States, what we have is a sectoral approach. So certain sectors that are deemed to be more sensitive and more likely to deal with very sensitive personal information are regulated federally. So for instance, the banking industry, healthcare, the transfer of healthcare documents, certain communications areas, online protection for children, or for children's activities. These are areas that are deemed to be extremely sensitive and for which the federal government has passed comprehensive legislation. But in the United States, you also have state laws. And so those come and generally preempt the federal law, not always. It's a bit of a web in the United States, but it's a very interesting regime nonetheless, and an effective one. There's also a self-regulatory model. And so what a self-regulatory model is I can use the United States again, is that companies that don't operate in a sector that is regulated federally nonetheless have to abide by certain fair competitive practices. And so what the organization does is it says, okay, you know what, I'm going to put together my own privacy policy. I will have it approved by the Federal Trade Commission. And if I'm in breach or found to be in breach of my own privacy policy, then that's an unfair trade practice, and I can be pursued for it. So that's a system where you're really deciding what works for you, and then it will be enforced by another body. And this is where the distinction between self-regulatory and co-regulatory becomes confusing, because co-regulatory is a system where the industry decides what I guess industry standards should be in place, and then leaves it up to another body to enforce those. So self-regulatory, co-regulatory have a lot of similarities. This is just so that we understand where we're going. And to help understand the different models around the world. The next So the next slide, then we get into Canada. How does Canada handle privacy? I'd like to talk about 3 issues here. Privacy of the individual vis-a-vis the state. So what are my rights when the state intervenes on or infringes on my privacy? What are my rights? And this is a very recent development. What are my rights vis-a-vis another individual who infringes on my privacy? And then finally, what are my rights vis-a-vis organizations? And that's really where I think the bulk of the litigation is today, and the bulk of the interest is, oh, these companies are taking my information. What are my rights? How can I defend myself against this? So when we talk about privacy of the individual vis-a-vis the state, I'm talking about intervention and behavior on the part of government organizations. And as a citizen of Canada, my rights are protected, as you know, by the Canadian Charter of Rights and Freedoms. The difficulty there is it only applies to behavior on the part of state institutions, public actors. It does not regulate people's behavior towards each other. So it doesn't regulate a discriminatory comment or an offensive comment that I may make or that somebody may make towards me, but it will regulate something that a public body makes towards me. And interestingly enough, in the Canadian Charter, there is no explicit protection of the right to privacy. What we've had to do is we've had to read it in to the provisions that deal with criminal law and criminal procedure. So we read it into sections 7 and 8. And these are sections that deal with the right to life, liberty, and security of person, and the right to be secure against an unreasonable search and seizure. So what number 8 or section 8 means is that law enforcement can't just wander into my house and start rummaging around. There has to be a reason for them to do that. They have to have a warrant, and they've got to be respectful of my right to privacy. And the way the court has then applied these in instances in which this argument has been raised is to say, okay, more often than not, it's law enforcement. Okay, law enforcement, you've infringed on somebody's right to privacy. Is this really an infringement? Is it justified? So the first thing they do is they say, okay, is there really a subjective right to privacy? Did the individual really think that they would have the right to privacy in this particular area or when they were in this particular space? And if the answer is yes, the court will then go on to interpret whether this expectation was reasonable. So there's a subjective test and then there's an objective test. So an example of this, an individual who was manufacturing drugs, not growing, but he was manufacturing drugs and chemical drugs, disposed of his equipment in a garbage pail that was in an alley or close to an alleyway. It was on his property, but close to an alleyway. The police reached through his fence, collected the information, or collected the paraphernalia, and then used that as evidence to prove that this person was manufacturing drugs illegally. The court said, okay, that yes, he may have had an expectation, a subjective expectation of privacy, because this was stuff that he placed in his garbage pail that was, after all, sitting on his property. But the fact that the police could reach in and grab that meant that objectively his expectation of privacy wasn't reasonable, and so they allowed that search. Another example was, the early examples deal with a lot of drug cases. An individual was growing marijuana in their home, and because of the energy consumption, their house emitted more energy and they were able to capture this excess energy through some sort of energy sensor. And the police did that to prove that the individual was, in fact, growing marijuana. Individual contested this in court, and the court said, okay, yes, this is your house, but this is energy that's being emitted outside. It's therefore in the public, the police did have the right to go and collect this information without a warrant. So those are examples of how you balance the reasonable expectation of privacy with the subjective expectation of privacy. What by and large has grown out of all of these cases is that there are three areas in which individuals have what the court calls a privacy interest. So that's a heightened expectation of privacy. Obviously, privacy of the person. My body, there's an integrity to my body. You don't have the right to just go and search me for whatever you want, whenever you want. That's a highly personal area. Another one is territorial, my home. Inside my home, also, I have a heightened expectation of privacy inside my home. I don't necessarily have that heightened expectation of privacy in a public area. And if I'm a public person, I lose incrementally, depending on how public I am, that right to privacy in a public space. But my home is still my castle, and it can't be violated without my privacy being breached unless proper warrants have been obtained, et cetera, et cetera. And then the final privacy interest that I find extremely interesting is what we call information privacy. And that's information that's contained on your mobile device or your computer. And the court has gone so far as to say that the nature and extent of information that these technological devices store and contain can be even more intimate and even more private than my own home. And they deserve a very, very, very sensitive protection. And this has led the court to decide that even SMS conversations, when an SMS has been sent out of my phone and received by the recipient, that recipient's phone cannot just be seized. That recipient has the right to the same amount of protection as would a conversation. And so you can't just go and seize somebody else's phone and expect that just because the information is left phone A, it has lost all of its confidentiality. And so very interesting developments, actually, especially in the area of information privacy. Are there any questions at this point? No? Okay. Let's talk about the privacy of individuals vis-a-vis other individuals. This is a really interesting area because it's developing now, and it's in Canada, especially common law provinces, a little late in its development. Quebec, however, has always recognized this, or almost always. Our civil code contains articles 35 to 40, which recognize an individual's right to privacy. Our charter, the Quebec Charter, which unlike the federal charter actually applies to individuals as well as public bodies, also recognizes a right to privacy. So Quebec, perhaps because of its civilian heritage, has always recognized a right to privacy as a human right. Common law provinces, not so much. It's taken a lot longer to develop. Some provinces do have tort laws, which mean that tort is civil liability. So if you cause me damages, I can then seek compensation for the damage that you've suffered me. It's the kind of damage that happens outside a contractual context. So there's contract law to govern a breach of contract, and then there's extra contractual or civil liability, civil responsibility that governs damages in which two individuals are not linked by a contract. So if you, for instance, throw a ball through my window and you cause me damages, I'm not contractually bound to you, but you are obliged to repair the damages. That's an extra contractual liability or a tort in common law parlance, and it's taken longer to develop that than it has to recognize it in the civil code. Two very interesting decisions here, both when the Jones versus Teague is 2012, and Jane Doe, I think, is 2016. But what happened in the first one was both women, Jones and Teague, work for the Bank of Montreal. Teague is living with Jones's ex-husband, and she wants to make sure that her partner is actually paying the support payments that he allegedly pays to his first wife. So what she does is she checks his bank account. They're both at the Bank of Montreal. She checks Jones's bank account because she has access to it, which technically she shouldn't have had, but she did, to see whether Jones was receiving these payments. That's all she did. It was snooping. There was no extra harm done other than that. Jones, however, was very upset, felt violated, and took this to court. It went up to the Court of Appeal, and it was finally recognized that Sieg had breached Jones's right to privacy. In common law, they call it intrusion upon seclusion. The amount of damages that Sieg was awarded were minimal. I think it was $5,000, and these damages are typically capped at $20,000. So there's no great incentive to find whoever's been snooping through your bank accounts and take a privacy action against them. The Jane Doe case, though, is interesting, the second one, because this deals with revenge porn. A couple, they break up because she wants to go to school in another town. She goes to school during her first trimester. She sends compromising photos of herself to her boyfriend. They split up afterwards. He gets angry, and he, I guess, publishes these photos or these videos, whatever they were, on the internet. She's extremely humiliated, loses sleep, loses classes, has health issues, and pursues her former boyfriend and wins. And she wins breach of seclusion, or intrusion upon seclusion, but the court then awards a tremendous amount of exemplary damages to her to punish him for this kind of behavior. So what we're seeing is we are absolutely seeing that privacy intrusions by individuals on other individuals are being recognized by the court and are being compensated when there is damage. The difficulty with this kind of a case, and the reason it's taken a long time for class action to develop in this area, is because of damages. When you're dealing with tort or extra contractual liability, you have to prove damages. And look, you've broken into my bank account. Okay, so you saw the transactions, but concretely, am I out of pocket anything? Not really. So that has always been the discussion when we talk about privacy actions, is the ability to prove damage. Now the court has turned around and said, okay, you know what, there is psychological damage. Yes, there's been a violation. Yes, we'll award damages in this area. Are there any questions about this before I go on to privacy with respect to organizations? No, okay. All right, so the privacy of individual vis-a-vis organizations. The law in Canada is a little tricky because we have a federal law, the Personal Information Protection and Electronic Documents Act, that governs data processing by federal entities, so federal works and undertakings like banks, railroad, airlines, what else? Post offices, these sorts of things within Canada. And then it applies as a default privacy legislation if a province does not have its own privacy legislation in place. There are only 3 provinces that do in Canada: British Columbia, Alberta, and Quebec. So they're exempted from PIPEDA unless we're talking about a federal worker undertaking. So a bank in Quebec is subject to the federal law. PIPEDA will also apply, or at least the federal government will take jurisdiction if we're talking about transactions that are cross-province. So if I have a Quebec company that has branches across Canada and there's a breach, it'll probably be the federal law that applies. Obviously, it may get contested, but it's better to go with the federal law. Public institutions in Canada are regulated by the Privacy Act, which is more or less the same approach, but just so you know that we're talking about private institutions, so we'll be talking about PIPEDA. Private sector organizations, Yeah, sorry, that was what I was just saying. We also have sector-specific laws in certain areas. So, for instance, healthcare. Most of the provinces have their own healthcare Information Protection Act, which we'll talk about tomorrow, and these are exempted from PIPEDA as well. Now, when we're talking about personal information, or we're talking about privacy of the individual with respect to the organization, we're talking about personal information. And what is personal information? It's information about an identifiable individual. Lovely, precise definition. It's huge, this definition. And it's the same in Europe, and it can include IP addresses, static or dynamic. It can include cookies. It can include obviously my name, telephone address. Coordinates. My employment coordinates in Canada and in the 2 provinces, Alberta and British Columbia, do not qualify. My work contact information, there you are, that's what I was looking for. That is not exempted in Quebec. Technically, it may be, a court may decide to exempt it, but in the legislation, that is not exempted. And so what are the activities that we're talking about? In both the federal legislation or the provincial legislation, as an organization, I can't collect, I can't use, I can't communicate, and I cannot store personal information without the person who owns the information without their consent. As I talked about before, in Canada, there is a sliding scale of consent. We do have the notion of implied consent in Canada. But unless I have somebody's consent, I can't do any of this activity. So the minute that you are dealing with personal information, you have to be conscious of the fact that the privacy or the data protection laws are going to apply to you. Even if it's for a split second, even if you're just processing information, you're processing my voice to be able to figure out whether more women or men call into a call center. So you have my voice that's linked to me, and then you scramble it to make your stats. That there, just that minute where you have my voice, that will be considered processing. So you have to be aware of that. Also, something I need to say is that if you've anonymized information, it does not fall under the purview of the data protection legislation. So anonymized information, truly anonymized information, does not qualify as personal information and is therefore exempt from the application of these laws. Bear in mind, though, that to truly anonymize something is extremely difficult. So it may not be the solution you're looking for. There are exceptions to the laws. For instance, health crises. If my employee is sick and passed out, I can transfer to the doctor, or I can transmit to the doctor or the ambulance healthcare technician that person's personal information so that they can be helped. So that I'm not completely barred from transferring information in the case of an emergency. If there's investigation of a crime, I may not have to. I may not have to adhere to the requirements in PIPEDA or any of the provincial legislation. That said, there have been cases where law enforcement cannot just say to an internet service provider, okay, I want all of the information on this particular account and expect to receive it. The service provider has the right to request that the law enforcement body or law enforcement person provide a warrant. So just because I'm allowed to disclose it does not mean that the person requesting it shouldn't produce a warrant. And then there are other activities that are typically, regardless of where you are, exempted. If I have to communicate the information for journalistic purposes, for archival purposes, scientific research also, and in Alberta there's an exception for union activity, which is quite interesting. Now, there are, although the private and the public sector laws, although the private sector laws are all based on the same principles as we discussed earlier, there are some differences among them. the first difference that's really striking is the purpose of these laws. In Canada and in Alberta and British Columbia, the purpose of the law is really there to balance the interests of the individual in protecting their private information and the interests of an organization in using that information. So there is a recognition by the legislator that, look, yes, privacy is a right, but it's not an absolute right when it comes to your data. An organization may require your information to do certain things, and therefore it's always a balancing act. And this is something that the courts said time and time and time again when they've been called to interpret this particular provision, is that one must balance the rights of the individual with the rights of the organization. Neither has an absolute right. That isn't the case when we come to Quebec, because Quebec's law, which predates the other laws by 7 years at least, its purpose is really to protect the rights of an individual with respect to the information that an enterprise collects. So there isn't that balancing component in the Quebec legislation the way there is in the federal and the provincial legislation. That said, courts try and interpret the laws so they're more or less the same, but you have to be aware of that distinction. Another interesting, and this is a really interesting one because it gets us in trouble federally, is that the provincial laws are coercive laws. So what I mean by that is the laws provide for fines. They're not excessive. They're not particularly high for certain organizations. And they provide for their own, there's a commissioner, the commissioner will investigate, the commissioner will fine. This isn't the case federally. The federal law, very interestingly, is what we call an ombudsman model. So the federal Privacy Commissioner, or the Office of the Privacy Commissioner of Canada, cannot fine. All it can do, and it can impose penalties. What it can do is it can issue a report suggesting that behaviors change, or not, but suggesting that behaviors change. If one of the parties is not satisfied with that report, they can appeal it, or if a body refuses to implement the changes that have been suggested, then the individual can appeal to the federal court. And interestingly enough, the federal court does not have to take into consideration the initial report. So the Federal Privacy Commission, although we have this law, has very little enforcement power. And anecdotally, when the Federal Privacy Commissioner was called upon to issue a report in the Cambridge Analytica scandal, its findings were very similar, identical to findings that it had made in 2009 when it had to investigate Facebook. Only nothing had been done. The changes weren't implemented. The report wasn't taken seriously. Why? Because it didn't have any enforcement power. And so that's a huge challenge that we're dealing with right now, is the fact that our enforcement body just doesn't have the teeth that it requires. So by way of a conclusion, what I'd like to say, I'd like to talk about are the challenges that lie ahead that are facing Canadian privacy legislation. The Quebec privacy legislation, as well as the federal privacy legislation, is old. They were passed at a time when we didn't have blockchain, when we didn't have the Internet of Things, when artificial intelligence was not as developed as it is today, and there is no mechanism to address these challenges. So it needs to be updated. It needs a facelift. The governments, before we got into this pandemic, on both levels had said, okay, we're going to start to update this legislation. It is extremely essential that we update our federal legislation because, and we'll see this next week, right now Canada benefits from what we call an adequacy status. Adequacy status is a status that's conferred upon certain countries, I think there's 15 of them in the world, and that enable the companies or organizations in these countries to trade with organizations in Europe, trade data. And the European Commission is extremely strict in saying that if you don't have adequacy status, then you need to have certain processes and procedures in place to protect data to the level or close to the level of what is expected in Europe. This places tremendous, tremendous onus on companies to be compliant. The United States does not benefit from an adequacy status at all. And so American companies have to really bring themselves in line to using model clauses, binding corporate rules, a whole bunch of legal documents and procedures in order to comply. And so we don't want to lose our adequacy status. And if we don't update our legislation, especially given the new legislation that's been passed in Europe, we may very well lose that status. So the other thing is that the European legislation has created new rights. For instance, the right to forget, which means I have the right to ask an organization that collects information on me to delete that information. There's also the right to data mobility, which is I have the right to ask that my data that's kept digitally be transferred to another place. And this whole idea of explicit consent. We allow for implicit consent. The Europeans require clear and enlightened consent. How is that going to work out? I don't know, but we definitely need to start facing the fact that our legislation is old and does need to be brought into the 21st century. So just to summarize, one thing that's important to remember is the influence of federalism on Canadian data protection regime, which means that we have data protection regimes both at the federal and at the provincial levels, and in some instances we even have sectoral regimes. So Canada is a blend of a comprehensive law like PIPEDA or like the provincial laws dealing with privacy, but also of sectoral laws, most notably in the healthcare sector, banking as well. It is a consent-based regime. Consent is extremely important for private sector data protection. It's important also for health sector, but the public sector, it's less so. But what you must remember in the private sector is that we really have to have the consent of the individual before we process their information. And then finally, the federal data protection regime is in need of updating. It must be updated to ensure that we're adequate with respect to European standards. So that is my presentation for today. I thank you very much, and I'm wondering, does anybody have a question?
Well, Danielle, while we wait for questions to come in, I have a sort of a question for you. What is
Sure.
well, by the way, thank you very much. That was a very interesting topic. What is in your opinion, the most common misconception that people have in the public, just the regular people like me, putting my data here and there and not understanding really what are the thing that, you know, we need to know that is not commonly known out there?
I don't know if it's not commonly known, but I think we're all guilty of it, me more than anyone, but I think we tend to underestimate the value of our data.
Yeah.
I really think that we don't realize how much that data is worth. And you know, if we are going into a digital economy, data is the currency. And you see that the Facebooks, the Googles, the Amazons, the Tencents, Alibabas of this world are all over it. And they know how much power they exert over all of us commercially just by having our information.
Okay, so thank you. We do have a question here. Are Canadians still protected when exception terms and conditions on US company pages?
It depends. Now, if you're talking as a consumer, your jurisdiction's consumer law applies. So you may have a wonderful, whatever it is, terms and conditions that is completely American law driven. That's good, but as a consumer, you're protected by your local law. So yes, you're protected by your local law, but then you got to figure out what that local law is and whether it does offer you the protection you're looking for.
Okay, so here we have a question. Do you, I guess, have a possibility for the conclusion of an international treaty in this field, bilateral, multilateral?
Oh, that's an excellent question. There's a lot of push in that area. I think Europe has definitely led the pack just because it's such a big trading bloc that if you want to do business with them, you got to do it on their terms. And you can see the fallout that's had where, you know, Brazil has passed legislation. China put in place legislation. The US is really, really, really changing its legislation. You see California coming on board. There's a lot going on. And yes, that would be great. And yes, there's a push to it. Whether it will happen, I don't know.
Okay, so here we have a question. Does the Canadian law address our privacy rights after we pass away? For example, our online data, our diaries, etc.
Oh my goodness. That I don't have an answer for right off the bat.
Good question.
I think, and I think I've heard this debated, that no, if you're dead, you're dead. Because it covers information relating to a natural person. And so a person who's deceased would not be considered a natural person. But it's an excellent question. It does get debated.
Okay, thank you. So here Jennifer is asking, why do you think some provinces choose not to have their own privacy acts? Is there a benefit for BC, Alberta, and Quebec to having their own? Any benefits?
It's another really interesting question. The funny thing with Quebec, BC, and Alberta is that while the federal government has been given adequacy status, that has not been extended to the provinces. So actually, ironically, companies doing business in those three provinces may actually have to comply with European legislation. So with that respect, it hasn't panned out very well. I think one of the pushbacks with respect to privacy legislation, I don't think people think that way anymore, but originally it was people thought, well, oh, if we put privacy or data protection legislation in place, what we're going to be doing is we're going to be blocking industry, we're going to be blocking innovation, we're going to be blocking development. And that was one of the reasons that we have federally an ombudsman's model, because we didn't want to be too tough on business. But now the tide seems to have turned, and when you've got, you know, Mr. Zuckerberg, and when you have other people defending stronger data protection legislation, I think we realize that data protection legislation and business go hand in hand.
Okay, thank you. Here we have another question. When capturing data on a website, is it just making sure our privacy policy and terms and conditions are properly and legally written, or is there more that needs to take place within the actual coding of a website?
That's a really good question too, and I am unfortunately not a coder, but I think that you have to, the obligation is to design your website and to code your website with privacy in mind. So if you can show that you thought about privacy in the way that you went about programming, and what I mean by that is programming so that if you're collecting information, make sure that it's collected and stored in such a way so that if an individual wants to have access to it, they can easily have access to it. If they want to correct it, they can easily correct it. If they want it transferred, they can easily be transferred, that sort of thing. And very careful, if you are using analytics in the background, you have to disclose that, and you have to disclose the extent of what they're doing.
Okay, so here we have from Rocho. Hi, thank you for the webinar. I would like to know if a logo is private and which are the steps to follow to register one.
Trademark, that is a trademark question. If you want to register a logo, I have a trademark department in my firm that's phenomenal to help you with that. So now I've promoted my firm, but it has to be registered, and it has to be registered locally. So it's not something you can register once and will be respected around the world. It has to be registered in each jurisdiction in which you want to carry out business.
Okay. So by continuing to use our site, you agree to our terms, service, and policy, privacy policy. You can learn more about how we use cookies by reviewing our privacy policy. If this is in every site, obviously nobody will read it. So did the site visitor provide consent?
Yeah. There have been a lot of judgments on that one because it gets right to the bottom of the consent issue. It's a great question because it really knocks the stuffing out of consent. Consent is, I believe, an absolutely delusional principle because you can't consent to anything anymore. Not truly. I don't know how my information is being proud. And so that is an example of implied consent. I don't have to tick the box anywhere that I've agreed, but I keep using the site. And sometimes it's a browse wrap, a kind of agreement. I just keep browsing on the site, and therefore I'm using it, and that can be deemed consent. Yeah, I would, if I were advising, prefer to get a much more explicit consent. But yes, that's the way that many policies are drafted.
Okay. Here, I have one last question. How do you enforce our privacy laws to companies not located in Canada?
Well, also a great question, very topical as well, because we've had this issue. What Europe does is it just says, okay, you know what? You don't want to respect our laws, we're cutting off data flow. So your branch here in Europe will no longer send data to you in Canada if you're not going to respect. And that is huge. If you think the implications of not being able to have access to your data, that's enormous, and that's what we're scared of. How does Canada do it? Canada, interestingly enough, is becoming a lot more aggressive, which I think is great, in defending our rights extraterritorially. The difficulty is, as you know, enforcement. If you have to go and enforce that decision in a different jurisdiction, the different jurisdiction, depending on the jurisdiction, but let's take the United States, for example, will only enforce that decision if they recognize the same concepts in their own law. And so if you're not recognizing the same concepts, typically the court will say, you know what, that's a great decision, but we don't recognize it. So it's a very complicated question.
Okay, thank you. I think that concludes our question. Just giving a look at the time. It's already 2:30. If there are no more questions, I think we'll close off. I want to thank you, Danielle, for giving this talk. It was very informative, and I hope to see you guys all back here tomorrow when Danielle continues with the health sector. So it'll be very interesting.
Yeah, look, thank you very much. The questions are phenomenal. So like each and every one of them, keep them coming. They're great. Thank you so much, Lucy.
Oh, you're welcome. Thank you, everyone. Have a great afternoon.
Thanks.